So, good morning, everyone. Today, I'll be talking about emotion AI in the workplace and the need for a thoughtful policy response. As AI systems become more integrated into workspaces, we have to consider the questions around privacy, fairness, and worker rights. So, what is emotion AI? It's a form of artificial intelligence that analyzes data from facial expressions, speech patterns, physiological signals, and even written text. Using this data, emotion AI can then infer the user's emotional state or attempt to. So, during my research into this technology, I found that these systems are being used in workplaces to monitor workers' engagement and productivity, identify stress levels, or even make hiring decisions. While employee tracking software is already quite integrated into Canadian workplaces, it's expanding into forms like Emotion AI, where it can be used to evaluate employees' capacity to remain attentive on the job, their ability to stay calm under pressure, their effectiveness in providing good customer service, as well as other aspects of performance. Recent studies have shown that emotion AI has the potential to incorrectly infer emotional states based on the data it collects, and workers are growing increasingly concerned about the employment decisions being made with the use of this data. They're also equally concerned about the privacy implications. In Canada, while there are legislative requirements to disclose employee tracking software use, there are no laws specifically addressing emotion recognition in employment. So clearly, there's a problem if we have an emerging technology that is potentially inaccurate in its ability to understand emotional states while claiming to do so. Emotion AI can be deployed in Canadian workplaces currently without clear safeguards in place. It poses significant risk to workers' rights due to its potential for inferential inaccuracy and privacy invasion, which could lead to increased stress for the worker, lower productivity, and unfair employment decision making. So let's map out the key stakeholders. We have governmental actors like the federal government and provincial and territorial governments, which will be interested in innovation, but aware of the rights-based concerns surrounding this technology. They'll likely take an approach that protects Canadians against harmful or discriminatory AI use. We have advocacy and civil society organizations who will advocate for stronger privacy protections and might host awareness campaigns to help employees understand the risks associated with this technology. They could potentially also engage in legal challenges should they feel that employee rights are being impeded. We have industry and business groups, which will work with businesses to ensure any sort of compliance with additional privacy laws, as well as navigating employee monitoring. They would likely advocate for less administrative burdens that come with employee privacy protection laws. We also have our technology vendors that are generally in favor of emotion AI, viewing it as a competitive advantage to develop locally. And then lastly, our unions, similar to our advocacy and civil society organizations, they're largely opposed to emotion AI because they likely cite risks to worker rights. So, in devising a solution, there are a few policy objectives we need to look at. Firstly, oversight and accountability to ensure the ethical deployment of emotion AI. We have transparency to ensure that employers clearly outline their use of employee tracking software and how it's being used. Employee agency to consider if employees are given the option to opt out of this technology's use on themselves. Minimal data collection to ensure that only necessary data is being collected from employees. Data protection to ensure that the data that is being collected is properly stored and encrypted for added safety. And lastly, the solution should ensure anti-discrimination and bias in its approach. So we have a few policy options available. There's the status quo option, which would rely on existing legal frameworks. For example, in Ontario and Quebec, where you're required to disclose if and why you're using employee tracking software as an employer. But these requirements don't add any further privacy protection for workers. We have the legislative option, which could legislate further protections for workers to mitigate any associated harms with the technology, or it could completely ban the technology from being used in workplaces. We have awareness campaigns, which would see advocacy networks and civil societies educate employees and employers regarding the potential risks and mitigations of emotion AI. We have tax benefits, which would encourage ethical AI use in the workplace by setting thresholds through which employers comply and then become eligible for tax deductions. And lastly, we have union led protections, which would allow for negotiated safeguards within employment contracts to ensure the safety of workers. So here we have a chart with the options against the policy objectives. And I just want to draw your attention to the legislation row where all the objectives are being met. Other options, such as the tax incentives, as well as the union-led protections, also fulfill some of these objectives, but they're not as robust and clear as legislation. So the recommended approach would be a legislative ban. A legislative ban would prohibit the use of emotion AI in employment settings. It aligns with the EU AI Act's Article 5, which could be a possible model. The EU AI Act bans emotion recognition at work, and this provision has been popular for prioritizing worker dignity over company profit. In Canada, the ban would clearly identify acceptable and non-acceptable AI practices, in this case, laying out clearly that any AI used in workplaces to detect and analyze emotion is not acceptable. Politically, this option is achievable if it's framed as a rights-based measure, especially with Liberal and NDP governments. Conservative governments are slightly more aligned with business interests. However, a case can be made for long-term cost savings by avoiding lawsuits and worker demoralization. Privacy commissioners, federally, provincially, and territorially, would also favor this approach, as they've previously called on governments to acknowledge the harms related to this technology and respond accordingly to protect workers. So there would be a hybrid model when it comes to implementation, where the federal government would set a baseline approach through the Artificial Intelligence and Data Act, which died on the order paper when Parliament dissolved. However, it's very likely that a resurrected AI bill will come forward, given how many countries are responding to AI use through clear legislation on acceptable and non-acceptable practices. Provinces and territories can then adapt these regulations locally through their privacy and labor laws. So, for example, in Ontario, the Employment Standards Act. In terms of cost, we're looking at around 15 to 30 million initial costs, and this is federal and provincial and territorial costs combined. This approach would involve funding for oversight agencies, training, and audits, but these costs are relatively minor compared to the costs of unregulated emotion AI use. There'd be a three-phased approach, starting with the introduction of an AI Act federally, as well as the development of companion workplace regulations, all the way to phase three, where we begin enforcement with clear penalties for violations. In terms of risks and mitigations, some might argue that banning emotion AI might stifle innovation, but this overlooks the potential for ethical AI development. By drawing clear boundaries, we're encouraging developers to innovate in ways that respect rights. Industry pushback is also likely, but this can be mitigated through consultation as well as robust public messaging. Um, Allowing misuse of this technology could ultimately erode public trust in AI, and this is an outcome we need to avoid. In conclusion, emotion AI is not just another workplace tool, it's a technology that attempts to quantify something that's deeply personal, our emotions, our thoughts. Without safeguards, it risks undermining worker rights, amplifying bias, and distorting human relationships in the workplace. A legislative ban modeled after the EU AI Act and global best practices could be tailored to Canada's legal system and is the most effective and responsible response. With the right framing, it's also politically achievable. Thank you, and I welcome your thoughts and questions.